What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we're going to be breaking down Hank Brennan's closing argument. Did he do enough to prove this case beyond a reasonable doubt? Number two, we're going to be listening to one little snippet of the jury instructions about the verdict forms, what to do on each individual count and charge and piece of paper. And then we are going to look at the verdict slip all bright and early on this Saturday morning. Thank you for being here. And on the West Coast, welcome very early or as part of the Rewatch crew. Let's get to it. So we are going to start with Hank Brennan's closing argument. And we're going to listen to a lot of it, like I said, with Alan Jackson, not every single word or every single minute like we did with Alan Jackson's. We're going to compare and contrast the two closing arguments, but they have different jobs, okay? Alan Jackson, really, his job is to highlight the reasonable doubts, really raise that bar up for beyond a reasonable doubt, explain how certain you have to be in order to come back with a guilty verdict. His job is to poke as many holes, blow holes, drive trucks through holes in the Commonwealth's argument. Hank Brennan's job is to show how this case is ironclad. He has to explain to them what happened, prove to the jury what happened, prove to them what the evidence shows and explains had to have happened that night, and explain to them why. Why are we here? What is the point of all of this? Why did we spend $400,000 on an expert? Why did we bring this case to you? Justice. Justice is important. We should all care about justice. You are administrators of justice today, members of the jury. That is the goal of a prosecutor and of Hank Brennan. Make them want to bring justice and help these victims. That's what the system is for, is to get justice for victims. And he starts out his closing argument with potentially the strongest part of this entire case.
46 years old. He spent his life.
Oh, that's Peter Speed. Let's try that again. Why is it so long?
John O'Keefe was 46 years old. 46 years old. He spent his life helping people. He's described as a good man, kind, generous, thoughtful. He was a Boston police officer. He worked to help the community. Everything you've heard about this man, he was a good man. He helped people. When his niece and nephew had nobody, he took them in. He took them in. John O'Keefe seemed to be the type of person who would help anybody at any time. And on January 29th, 2022, John O'Keefe needed some help. He needed help from somebody else. You see, John O'Keefe had just been hit by Karen Reed in front of 34 Fairview Road, and he lay on the ground dying.
All right. So he says John O'Keefe was a good man. John O'Keefe was somebody that was willing to help anybody who needed it. John O'Keefe needed help that night. When his niece and nephew needed help, he was there. When anybody needed help, he was there. And to me, that's the strongest part of this case. John O'Keefe was a good man. He was a cop. He was an uncle turned father. He was a good son, a good sibling. John O'Keefe was a good man. So what does that do? That makes the jury sit up in their seats like, we got a job to do. Let's not forget who this trial is about. It's about John O'Keefe, the man who tragically lost his life that night. And from my perspective, that is where you want the jury's mindset to be to start. Carla said, I did appreciate how he wasn't reading from his binder. And from my perspective, That's always a bonus. That's always a bonus. I try to do that. I use very few notes. If I do, it's an outline that I'll reference and still walk around and talk. They'll give me, here's the next point. I've seen it done well both ways. I do not like at all when somebody sits there with their head down the whole time reading. That you lose effectiveness. You lose engagement, in my opinion. Sorry, Peter. I don't know if you can go through this emotional blackmail again. He lies. Listen, you can call it emotional blackmail, but there is a realistic element. The defense, both sides are going to deal with emotions because emotions are part of this case. And they're part of most cases. Now, does he say things that aren't true? We're going to get there. Perhaps the most impressive thing from Alan Jackson this entire trial was his ability to sit quietly during Hank Brennan's closing. And what I will say is both lawyers did that. Neither lawyer got up and objected unnecessarily. John Stamos announced he is free Karen Reed. Where did he announce that? My Greek brother, John Stamos, Uncle Jesse, Wiggle Pickle. So do you think there's any appellate issues? I think there's tons of appellate issues, but let's wait to see if we even need to get there. I felt gaslit Hank's entire closing. All I could think was there's no collision. And I will tell you, that is exactly what Alan Jackson wants you to think. They want a juror to sit there and think the whole time Hank Brennan's talking, prove to me there was a collision. If Alan Jackson can get you to think that, he has won the day. He has done his job. Who's to say the phone didn't fall out of John's hand pocket and then that's why it didn't move? And all they proved is she backed her car up and the phone didn't move. Defense proved no collision, not guilty. Listen, from my perspective, that's an unanswered question. Unanswered questions are not good for the prosecutor. Not good for the prosecutor.
And he needed help. Someone to reach out a hand, someone to knock on a door, someone to make a phone call to 911, even anonymously. Not take responsibility, just to help. And there was only one person in this entire planet who could help him that morning, to give him a chance. Maybe it was a 33% chance if he met the Isaac Wolf of the world, but to give him a chance. And that one person who could help him that morning was this defendant right here, Karen Reed. And she made a decision. In her Lexus with the shattered taillight, debris field all over the front yard, and John O'Keefe lying helpless like a child in the front yard. She made a choice. She didn't call 911. She didn't run to his aid. She didn't knock on a door. She made a decision about herself. In her Lexus, she drove away.
So one problem, if I just want to point out some stuff that I think the evidence shows and what the defense created as well, is there were multiple people inside 34 Fairview expecting John O'Keefe to show up, seeing Karen Reed's outside John O'Keefe's 34 Fairview, and they never went out either. They could have knocked on a door. They could have walked outside. They could have rendered him some aid and helped him as well, and they never did. So when you throw that type of angle at this case, I'm not sure it plays well.
She was drunk. She hit him, and she left him to die.
What does that remind you of? She was drunk, she hit him, she left him to die. That reminds me a lot of what the jurors from trial number 1 said. That's what that reminds me of. Simplify it down to, well, those 3 things happened, so what are we going to do? And that's going to be important when we get to the verdict slip.
She was drunk. She hit him, and she left him to die.
By the way, I didn't back it up. He repeated that, so I'm going to let you listen to it again.
She left. She was drunk. She hit him, and she left him to die. She was drunk. She hit him, and she left him to die. Before I go through and detail the evidence, let's talk a little bit about the evidence as a whole. She was drunk.
Before I go through the evidence, let's talk about the evidence.
She was drinking that night. She was drinking McCarthy's with John. She was drinking at the waterfall. Her blood was taken with samples of a retrograde analysis, almost 2 to 3 times the legal limit. She was drunk. She hit him. The timeline in this case is beyond dispute. You can accuse, assault, characterize, malign, twist. The timeline doesn't change. It is data. Data is data. The black box, the forensics from the SD card, we know exactly step by step where they were. We know in that window, she hits him because he never moves again. His healthcare data, the temperature on the battery of the cell phone, the physical evidence, the debris field, the DNA, the hair. And then she left him to die. He had a.
So I also think we're gonna catch some themes of how he does things. Sleuthy said he sounded like he got stuck on a buffer loop. So that's the risk of going no notes and no outline, right? Is you kind of lose your spot. So what do? You repeat some taglines. Sometimes that happens, which again, you give and take when you're going to go no notes. And some jurors, I will just tell you, some jurors have come up to me after trial and been like, how did you do that without notes? And I had a PowerPoint. So it's like, I have a PowerPoint with like pictures, maybe not a bunch of words. I don't put a lot of words on my PowerPoint, but they strike in my brain like, okay, this is what you need to talk about next, right? The same way kind of I do these shows, right? I just have like timestamps. And when we listen to the timestamps, then I talk about what happens in the video that we're talking about, right? But some jurors find it impressive. Others may be like Sleuthy and notice, why do you keep repeating these things? It sounds like you're getting lost in your own argument. I'll also say one of Hank Brennan's crutches to me is he just throws stuff out there like data, black box, DNA, but he doesn't actually connect them like Jackson would connect. This is what Dever said. This is what the video showed. This is how that works into our theory. Brennan just kind of like tells a story and then throws out stuff like data. I think he also early on, and in the beginning, you should focus on a lot of the strong parts of your case. And early on, he talks about she's drunk, the blood alcohol level that she had, how they did the extrapolation, the scientific sounding things, which there are issues. And again, if this was just a common DUI trial, I think the defense would have been very different picking that apart. But that is strong evidence. You have Karen Reed basically admitting she was drinking and driving and drinking too much. And I get what people are going to say and push back on the details. Fine. That is a stronger part of Hank Brennan's argument. Some of the major parts are very weak and difficult. So you got to pick your strengths and try to start out with your strengths. But he needs to marry the evidence with the story he's telling so much more. Again, my dad and I were watching this yesterday when we were playing golf yesterday morning. And we're like, sounds like an opening statement. He's just telling a story. He's not arguing like, we proved this to you with this piece of evidence. Even if you want to twist it and see it the way that you see it as a lawyer, which closing arguments you can do, I just didn't feel enough of that. It really felt like he was just telling the same story as if this was opening statement.
Basal skull fracture, counter coup, you heard all about it when the back of your head hits the ground and the brain comes forward. Dr. Wolf told us the reason why they have level 1 trauma centers around the country is because people can survive this injury if they get help. That's why they have this care. That's why they have these hospitals. But you got to get help. You got to get help. And if you don't, you develop symptoms, ecchymosis, raccoon eyes, your brain swells, and you die.
Okay, so just another issue. And I'm going to pause it a lot. Okay, whatever. I don't know why I apologize doing this on this YouTube channel 4 years in when it's the same every single video. But another problem. A problem with all these different counts, right? We said when you have count 1, which we think is difficult, count 3 is difficult because the mens rea, the mindset, count 2 is their best chance, especially with all the lesser includeds. We're going to look at the verdict slip. But when you have all these different counts, it's also a little bit like, what are you arguing, bro? It sounds like now it's more of a left him there to die, count 3 type of deal. Or is he saying that she intended to do this and wanted his life to end? But if she was going to drive away and try to get away with it, and leaving her taillight shattered behind, like it doesn't, why would you do that? Everybody's going to know it was you if it actually happened the way Hank Brennan explained it. So I think all these different counts were confusing. If he would have just focused on count 2, I think he could have had a clearer and easier way of trying to say, she didn't mean to. It was an accident. She was drunk, but it happened. She didn't realize it. She didn't want to end his life, but she got angry, sped backwards, and then left and didn't care what she hit. Whatever. Just, it would have been better to me if he would have focused on count 2 and even the lesser includeds of count 2. But I get why you do multiple charges, because the jury says not guilty on counts 1 and 3, makes them feel better about just one guilty verdict potentially to split the baby.
She was drunk. And that night was a recipe for disaster. But before we get to the drinking, in some ways, the fate of this night was sealed well before that night, because John O'Keefe and Karen Reed were in a toxic relationship. This relationship was crumbling. We hear lovey-dovey, and it was crumbling, and we know it. And we know it because a month before, his niece Kaylee talks about when they went to Aruba. It should have been a wonderful event. It was discord. It was fighting. It was aggravation. And when they got back, the discontent was palpable. Miss Reed reaches out to Brian Higgins, text messaging. John O'Keefe, the relationship is crumbling. And you heard a little bit about what that relationship was like. Kaylee, his niece, told you, when there was an argument, John would do what John does. He would walk away. She described to you one time, to get away from the scene, he walked into his bedroom. But the defendant wouldn't let it go, pounding on his door, having to get the last word, never letting go of the fight. Kind of mirrors what happened on January 29, 2022.
Does it? Is that the same thing? Like, is that the same thing at all? And again, Kaylee's testimony was probably very powerful and probably going to pull at the heartstrings and emotions of the jury as well.
And maybe outward appearance, they got along. Maybe sometimes quietly they got along. But behind closed doors, relationships have up and downs. We have a bird's eye view into the relationship on January 28, 2022, because we have the text messages. Not so lovey-dovey. The relationship is almost over. The tensions are simmering beneath the surface. They are not getting along. She believes Mr. Keefe is already halfway out of the relationship and he's not into it anymore. You will read him.
Did he call him Mr. Keefe too? Like, listen, I've talked about this with my dad, screwing up names and stuff. If you're a prosecutor, you really can't screw up the victim's name. There's a lot of names you can screw up. There's a lot of names going on in the case, but that's a tough one. If that's what happened, that's what I heard when I listened to it. I don't know what the jury heard.
Saw them. This relationship was unstable and at its end. And so fast forward that night. That night, after this discord, after the arguing, they go out and what do? They drink. And they drink a lot. So Keefe drinks a lot, and Karen Reed drinks a lot. You've seen the McCarthy videos. You can call it 6, 7, 8, whatever you want to call it. You can see the shots into the mixed drinks. More shots into mixed drinks. Count them yourself. Over a half dozen mixed drinks in just a few hours. Sober. And then at the waterfall, a shot, a mixed drink. Now, it was brought up the waterfall that there was some type of discord between Brian Higgins and John O'Keefe. They knew each other. They were friends. Brian Higgins' conduct of speaking to Karen Reed is not honorable. It's not. But they were friendly. There was no adversarial relationship. There was no anger between them. What we heard is they barely greeted each other. Can we have slide 1, please?
And this is why, okay, I loved a lot of what the defense did, especially the closing argument, but I mean throughout trial and how they adapted their strategy, which I think was smart. But the focus on Brian Higgins and the argument that she wasn't really drunk or she was drinking at home, those are two of the ones that I think Hank Brennan could attack and could make it look like the defense is wrong. Now, there's so many other reasonable doubts besides those, but any ones that you can eliminate as Hank Brennan, you have to do. And I do think he did a pretty good job with the fact that she was drunk, drinking a lot. Like somebody said, Valerie said 20 times. Yes, he just kept saying it over and over again because I think that's a good fact for him. And then this Brian Higgins exchange in the way he explains and really dampens the Brian Higgins motive, whatever you want to call it, I actually think was effective. Now, we'll get to the collision issue and the injuries issue that are horrible, gaping, reasonable doubts, but dealing with them one at a time, I did feel like he did a good job using the video here. Peter, will your dad represent Cleo in a movie deal? Absolutely. Absolutely. He would love Cleo.
At the waterfall bar, when you see John O'Keefe come in, here's him barely greeting him. That's him, and Mr. Higgins, barely greeting each other. Reality sometimes is different than argument.
Reality sometimes is different than argument. Okay. They didn't look like they hated each other. They gave each other a little hug. It didn't look like they were going to fight, right?
Celebratory mood. Take that down, please. Celebratory mood. A bunch of friends. They're playing around. They're hugging. They're grappling. This is a fighting technique for a murder 2 hours later. Is that the story? They're practicing their moves to murder John O'Keefe. In the celebratory mood, you don't see any aggravation.
I think that's a pretty good. I think that's a pretty good response, in my opinion. A pretty good response. That's not what's happening there. They're not. I find it hard to believe that that's what's happening there. I do agree with that. So if that's all he had to prove, or if he was a criminal defense attorney and he was trying to poke holes in Brian Higgins' story and he was Brian Higgins' lawyer, I think it would have been okay. Unfortunately for him, he is the prosecutor in this case and he has to prove what Karen Read did. So this was kind of the first chunk of his closing, but getting into proving what Karen Read did, woefully short. What's up, everybody? Having a big 40th birthday gathering today, and hubby gave me an early gift, some Lawyer You Know swag. Thanks, Lenny and Peter. Pita. Free Karen Read. Chris K, if Karen is acquitted, what is the risk benefit of the defense calling out the judge and Hank Brennan's biased behavior? I mean, I don't think they'll really call out the judge. They might call out Hank Brennan, but you want to be a gracious winner. Okay. That's the number one thing. If you win, go be a gracious winner. That's what I would say. The timeline in this case is beyond dispute. He said that with a straight face. Then a few minutes later, no evidence, no witnesses, no data. Hank Brennan, more importantly, no burden of proof. Why don't we ever see Kelsey's new intro, outro? We're still working on it. We had like music issues with trying to, because we bought the rights to it, and just YouTube is a crazy world. Hopefully we'll get it up because I do love it too. BLT, Pita. I haven't missed a Lawyer You Know recap or a podcast with you and Papa T. Uncle Jesse is now my third favorite Greek after you too. Boom. Thanks for your thoughtful and fair commentary. You are great at this. Stay cool this summer. I will do my best. It's freezing in here. It's 1,000,000 degrees outside. That's why I have a sweatshirt on. My Lawyer You Know sweatshirt, by the way, probably one of my favorites. All right, let's get back to the closing.
Or animus between Brian Higgins and John O'Keefe. Inevitably, the next morning, Karen Read is brought to the hospital and they take her blood. Now, the government doesn't have to prove that she was drunk. It is either that she's over the legal limit, 0.08, or she had enough alcohol to affect her ability to operate a motor vehicle safely. But you will know.
It's always, we do that because it's like, what does drunk actually mean? Above the legal limit, normal faculties impaired. That's a normal DUI argument. But to simplify it, he's going to just say the extrapolation's over 0.08, and there is evidence that she was impaired.
That she was far beyond the legal limit. After the retrograde analysis, almost 2 to 3 times the legal limit. Almost 2 to 3 times the legal limit. Now, it's been intimated, not come out and said, that maybe she went home and started drinking after she got home. No evidence, mind you, no evidence. And that somehow that is why she had a high blood alcohol level. It's not appropriate for me to comment on the credibility of another attorney's argument, so I won't do that.
But you did. Like, you can't be that guy. I'm not going to say, it wouldn't be nice of me to tell you your hair sucks, so I'm not going to say it. It's like, that's exactly what I try to teach my kids. It's like, no, you did it. You did the thing you shouldn't have done. You gave the effect we didn't want to give. That's exactly what you did. So can you please not do that? He's like, it's not appropriate for me to call Alan Jackson a liar, slime bag, scumbag. So I'm not going to say those words. That's what he said.
But Karen Read will do that for her. So if we listen to slide 2, she'll tell you exactly what she thinks about that claim.
My alcohol intake's probably about 5 or 6 or 4. There's drinks that they reported at more part at the time. It tasted just like old soda water with blue lime.
Slide 3, please.
I agree, Brian, but I'm just telling you, with the evidence that they have, pretty good argument that she even admitted drinking too much before driving that night for most jurors. I'll just tell you, for most jurors, that would work. Tried a lot of DUI cases. For most jurors, the evidence they had in this case worked. There's a lot on the defense side, and again, I'm repeating myself, but we would have heard a ton about exactly what they did and all this evidence if this was just a DUI trial. But a little secret like Alan Jackson, I think the defense would love it if the jury just checked OUI, guilty, and everything else not guilty. I think they would say that was a huge legal strategy and win.
wouldn't have gone on the expressway. I would have gotten on the expressway at 12:15 on January 29th. And it was quiet, the roads were very quiet, you can see on the videos. And I was going, when I've had a few drinks in the driveway, at least for extra souls, I go my alerts aren't as sharp as they should be. But I shouldn't be driving.
Thank you. Do you think she drank when she got home?
She may have drank when she got home. She may have drank when she got home. That doesn't change the fact that she drank a lot before getting behind the wheel and driving. Jesse H. Closing with video that demonstrates legs are not hit, but arms are destroyed. Thank you so much for providing an equal opportunity for him. Happy Father's Day to you and Papa Peter. Do we really have to listen to this? LOL. Have you ever had a closing where it felt like insurmountable odds? And what did that feel like? So yes, I think it's important to listen to both. I do. If you don't want to listen to both, like, it's tough to have the full picture and try to understand where the jury's at. Okay. That's my opinion. Number two, yes, I absolutely have never as a prosecutor, never, ever, ever did I prosecute a case and feel like I had no shot at closing. Yes, as a defense attorney, and it's very hard. And you start picking apart, like, did they actually prove it? Is there enough evidence here? But there have absolutely been cases where I'm like, regardless of what my client says, man, there seems like there's a lot here. Or I know how jurors look at cases like this and certain charges. You walk in and the judge reads the charges for your client before jury selection, and you can look at some jurors' faces, and it doesn't matter what you say, they're probably going to vote guilty. So yes, I have felt this before. It sucks. I hate it. I hate it. And because of my crazy competitive personality, that's also why I like civil cases better than criminal defense cases, because you lose a lot as a criminal defense lawyer. You lose a lot. Did defendant ask for OUI as an out, split the baby? That could easily be appealed due to the timing of the blood test. I don't think that's going to be an appellate issue as much as it's not going to crush Karen's life like a lot of the others. And yes, it seemed like the defense was the one asking for that. Jenny, my first live question. How was final jury foreman determined? The judge selected it. Hank Brennan is not likable or effective, in my opinion. Crazy case, not guilty. So a lot of people ask me why Judge Cannoni does things the way she does with the jury. I don't know. It's very different than any case I've ever tried. Is this where the jump is? Yes. Okay, I'm going to jump here a few minutes. They talk about John O'Keefe leaving the waterfall with the glass and the straw. I also thought it was not a great argument for the defense to act like that glass was not from the waterfall. We do see John walking out with it. Karen says he has it. Like, just pick your battles, from my opinion, but they want, a lot of different reasonable doubts, so I get it. He leaves the waterfall. They get into the Lexus. Burgess, when you can't attack the data, attack the man. As much as they want to make fun of him or mock his CV, he found the key to this case. That's a man apologizing for his own case and his own expert. Never good when you find yourself there. That's something I've never had to do. I've never had to be like, well, I know he kind of sucked. Never have I ever done that. He plays the clips of Karen saying John used to hook up with the girl and they're on the way to the house. Climbing in the cell phone data doesn't mean stairs just because he says it, right? Again, there's one of those things he says, just because I say it doesn't mean stairs. It doesn't. Data was clear when the 3-point turn was. Nobody sees him go inside. That matches the Apple Health data. He keeps telling the story of all these witnesses, none of whom saw the actual alleged crash. That's a problem. Because you're telling all this stuff. He focuses on coup contra coup and all this stuff, where they drove and 3-point turn. None of that stuff actually proves a collision. That's the problem. And while I know the timeline can be a good visual for him, he has to prove a collision. Nobody said exactly where he was, but we know he walked for 20 seconds and he couldn't walk into the house even by the defense expert's own measurements. It's like, how do we know this? How do we know that? You're just saying it. You're literally just saying it. Give us some proof, right? That's what you need in this closing argument. All right, we're going to jump ahead and listen to some more.
And then it happens. We know from the uncontroverted uncontroverted data from that black box. We know that Karen Reed, after he gets out of the car, drives away. She drives for at least 33 feet away from him. He's back near the flagpole. She's gone. It's over. Whatever argument is over. Whatever anger and flame has been dispassion, she's moved on. He's separate from her. He's safe. And then she makes a decision. That's what this case is about. Then she makes a decision. She could have driven home. She could have broken up with him. They could have talked about it the next day. But like knocking on the door, like Kaylee said, getting the last word, she doesn't drive away. She takes that 6,000-pound Lexus and she makes a decision. And the decision is that she steps on the gas after banging it into reverse. Before we talk about what happens next, I want to talk to you a little bit about the charges in this case. And I hate
This is important when he gets into the actual charges and what they have to prove and how he's proving it.
to digress, but it's important so we really understand what we're talking about here. I have no authority to talk about the law in this case. The Honorable Judge Cannoni will do that. But I want to talk to you a little bit about the charges. Don't rely on my interpretation of the law. It's the judge who has that special power. But I want to explain to you a couple of things so when you think about what happens next, you can really assess the facts of this case with the charges against Ms. Reed. She is charged with second-degree murder. It sounds ominous, it is. It's a serious charge, second-degree murder. When most people think murder, they think shooting or stabbing somebody. It's natural to think that. Second-degree murder is different. It's not first-degree murder. I told you at the beginning of this case, I told you that we were not going to suggest or try to prove that Ms. Reed intended to kill John O'Keefe. That was never part of this case. We're not claiming that. I told you that we were not ever going to try to prove that she even intended to hit him. We never suggested we would try to prove that, and we're not trying to prove that she intended to hit him. We're not. What we are obligated to prove and what we have proven from the evidence in this case of second-degree murder is that she intended an act, and that is putting the car into reverse and heading back towards John O'Keefe. She intended that act. The question then becomes, did her conduct create a clear, plain, strong likelihood of death? Late at night, dark, beginning to snow, under the influence of alcohol, knowing where she stopped and left him after an argument, heading back in reverse to the exact spot or right near where she left him at over 24 miles per hour, accelerating at over 75%. You need to ask yourself, are you convinced if somebody does that create a plain and strong likelihood of death? And if there's no...
This always with me has been a difficult time to get here because so many scenarios would end up being second degree that just everybody knows are not. That's the problem. It's so much better as a theory under count two, but
doubt in your mind that she intended to hit that accelerator in reverse, and if that conduct will create a clear and plain likelihood of death, then she is guilty of that crime. Whatever the label is, she would be guilty of that crime. Now think about this. Let me give you an analogy. If somebody, maybe a teenager, someone young, impulsive, is on a bridge and they see cars going by and they have a boulder and they want to throw the boulder off, they're not looking to hurt anybody. They're not meaning to kill anybody, but they throw the boulder off the bridge because they want to see the car break, the thrill. And when they throw that boulder off the bridge and it comes down and lands on the car and then somebody, passenger, anybody in that car, and it then goes through the roof and kills the person in the car, did they intend to kill that person? No, they were trying to have a thrill throwing the rock.
to me, very, very different. Or it's like firing a firearm into a crowd or up in the air, or all of these things, to me, is something that makes sense for second degree. Because when you have a situation where you're driving your car drunk, there are multiple charges for that. Or it would just always be second degree. Now, sometimes it can be, depending on how you're driving, depending on what you're doing. But he's not giving us any more than that, from my mind at least. Again, we're just talking second degree.
Did they have the malice to want that person dead? No, they didn't. But that would be an example of second-degree murder. When you take a boulder and throw it off a bridge, there's a plain and strong likelihood of death. When Karen Reed, in the midst of that tension and fight, after she drove away and was gone, disengaged, when she came back for the last word, in the darkness, the beginning of the snow, under the influence of alcohol, and decided to stop her Lexus, decided to put it in reverse, decided to accelerate 75% in the exact same direction of where she left him, and then hit him, and he died. I suggest to you.
Gina, I agree. But it's kind of got to happen outside of trial. I feel like nobody would ever, you have to understand, like when you read a jury instruction, when a judge reads a jury instruction, the lawyers have to agree to it. And I don't feel like most lawyers will agree to telling a jury what the real job of each other is. It's like, it's just kind of hard. That's why I like stuff like this. Gives the opportunity for lawyers to come on and be transparent, tell how it really is, and how the world works when you walk in there. But obviously everybody doesn't watch, but one at a time, right? One at a time.
That is second-degree murder. The other charge, operating under the influence of alcohol, manslaughter. It's different. It's a totally different and separate charge. Was she under the influence of alcohol? And then secondly, did she operate her Lexus wantonly and recklessly in a way that would very likely result in serious injury?
Okay. If you prove a collision, I can understand how some jurors might go between, count two and the count two lesser included, right? If they prove a collision and the injuries line up, I get it. And listen, there's taillight on the lawn. There's taillight debris in his sweatshirt. There are scratches on his arm. And if you look at it and you're like, to me, that proves a collision. And I don't care that, the scratches look like dog bites, or that, the amount of scratches don't line up with the amount of taillight, and, no bruising and no lower body extremity and no fractures. And you don't care about that. These are where I think I could understand people sitting.
When you're under the influence of alcohol and you drive a 6,000-pound Lexus in the heat of the moment at the direction of where somebody is, whether you intend to hit them or not, I submit to you that is wanton. It is reckless. And any reasonable person would think it's very likely that serious injury would result. It's not a matter of intending to kill. It's not a matter of intending to hit. It is the conduct of the operation and the risk that is created. And so those two charges are two of the three. The three is leaving the scene knowingly, causing death.
I mean, that one is almost like, this is where somebody said earlier, I don't feel like Hank Brennan was believing what he was saying. This is the one I felt like he didn't even believe it when he said it. They should have dropped count three, because you can split the baby with count 1 and 2. The count 3 is like, I don't get that. If they really think that she hit him and knew about it and left, I feel like they'd convict her of count 2, right? Like if the jury really believed she did that.
And we'll get to that. So now, sadly, we need to get back to 34 Fairview Road where we left. We know from the tech stream data that she drove 33 feet at least, because it only picks up a 10-second window. And when it starts to pick up the data, we know she's driving at a speed. So it's more than 33 feet. We just don't know. And then when she comes back, she covers the 33 feet and 50 more. 80 feet. 80 feet. Over 80 feet. Now, nobody has ever suggested, even Dr. Welcher, when she collided with them. This data doesn't tell you collision. It's a 6,000-pound Lexus. It's a 200.
It's not good for you, but it's true.
16-pound man. It's not going to show a blip. It could have been in that 10-second window. It could have been 2 seconds after. It could have been 4 seconds after. But it's in that pocket of time, and we know it. We know it because when you reconcile the data with the phone.
So somebody just said, and I have to say this, somebody just said, Hank Brennan's website says he helps with dog bite cases. So I just looked at his website real quick. What are his practice areas? Listed first on the left, personal injury, wrongful death, car accidents, truck accidents, motorcycle accidents. Then second, criminal defense. Doesn't that just make you laugh with everybody coming on here saying, Peter, you're a civil attorney. You just handle these injury and wrongful death cases. It's like, you'd be surprised how many criminal defense lawyers either do both or advertise both at the very least.
That 20 seconds is in the same window of that 10-second window coming back. So even if it's a couple seconds later, 4 seconds later, whatever Mr. DeSorbo wants, he stops moving. He stops moving. Forever. Forever. That's slide 6, please. You'll get to see this more closely. And you can't.
And that all that is, and I'm not making fun of Hank Brennan for that. It's smart, by the way, especially if he does it. It's a very good profession to be in. But that just tells you how people on the internet don't understand how it works to be a lawyer and what the differences are in civil and criminal. And people don't get it. Like, that's the point. That's why some things I'll explain more than others. But when people say stuff like that, it's like not worth getting into.
Probably see it where you're sitting, but there's important data. Data doesn't lie. And you will see acceleration, 75%. You will see speed, 24 miles per hour backwards. You will see distance, over 80 feet. That's what you're going to see in this data on that night. Anger, although not necessary in any of these charges, anger can be inferred. For somebody to come back that hard, that fast, that reckless, that obvious, likely to create a plain and strong likelihood of death. That data tells a story that can't be changed, can't be attacked. ARCA, they did some crash tests on me. You know what else they do? Texturing data. There's nothing about that data that is uncertain. Nothing.
But there's nothing about the data that is uncertain that I just told you doesn't show a collision. Now, in some cases, I have seen a timeline and it being, and even in some civil cases I've had where the evidence is tough, but the timeline works. Like, I had a wrongful termination case where it was a sex discrimination with a pregnant female who absolutely lost her job, got less hours, ends up getting fired right when she tells her boss she's pregnant, right? But he never said, I'm firing you because you're pregnant. The timeline worked so perfectly. That's why we won that case. Timelines can win you cases, but not when there's what feels like a mountain of evidence on the other side saying, but that's not how it actually happened. And there are other explanations for how that timeline got there. So I get why he's focusing on the timeline.
Take that down, please. When Ms. Reed hits John O'Keefe, collides with John O'Keefe. We don't know if he went in the air a foot. We don't know if it was how much of a clip it was. We don't know if he stumbled back, but we know there's a collision. There's no doubt there's a collision because her taillight's all over the yard. It's all over the.
There it is. And a lot of people, I saw some people in the chat saying that. So Hank Brennan did his job with you. There's no doubt there's a collision. There's taillight all over the yard. To me, if somebody's going to be with you, Hank Brennan, it's going to be that simple. So I actually agree with that. I agree with that argument. If they're with you, it's that simple. Ignore all the other stuff that creates an impossible and insurmountable obstacle for you. Ignore the diffuser. Ignore the crash tests. Ignore the sleeve of the sweatshirt. Ignore the injuries or lack thereof. Ignore them because it has to be that simple in order for someone to get there. The object of mayhem. Big fan Peter would love to get your breakdown on how Hank explains second degree based on the potential outcome of an action, independent of untoward outcome, SUV versus person. Legally speaking, it can be second degree. I just don't think that's what it's written for. And the example he gave is much better. Or taking a firecracker, throwing it into a car where there are people sitting in there. That's what, to me, it's more built for. And the fact of the matter, we don't have a throwing a firecracker in a car statute, but we have a driving under the influence, hitting and killing somebody, whatever. We have different statutes that have drunk driving in them. And we see some in here.
The yard. And when he falls back, and he hits the back of his head, his basal fracture, he's then lying there helpless. When Miss Reed leaves, she leaves behind tons of her taillight all over the yard. All over the yard. It's called the debris field. And you've seen videos. You can't replicate the exact contact. You can't because you need where the person was hit, how fast the person was going, but you know what happened because when you look at the debris field, when a light is broken, it's no different than what was on the front yard. It's no different. She leaves him behind. She leaves her taillight behind. She goes home. And on her way home, she's still angry. She's still angry because she starts leaving him voicemails. Slide 7, please. Healthcare starts at 12/31/56. 12/32/04 to 12/32/12 is the data which is adjusted and you reconcile the thoughts and Alexis. 12/32/09 is when Mr. O'Keefe closes his phone after looking at Jen McCabe's text. 12/32/16 is his last steps. Because the disorder says that red range should move a little bit 2 or 3 seconds. They can move it 4 seconds, 5 seconds. It doesn't matter. It's all in the same window. It doesn't change. We could have slide 10, please. Can you play that, please? Thank you. Each one of those pegs represents 10 feet. You can't place that car where it was in front of Fairview. You just can't. The data doesn't tell you that, but that tells you the movements of that car.
Just admitting other things that he can't prove. You never really want to do that as a prosecutor. You don't have to say it that way, the way that he says it. And listen, people are saying the debris wasn't found until later. Could have been planned. I get it. But I'm saying if you think she's guilty, it's probably as simple as she said she hit him. She said she clipped him. She was there. She was drunk. The car was there. The debris was there. He ended up there. She knew where he was. You have to discredit. And that's what every juror does. They give credibility to certain things and they discredit other things. So then he plays the voicemails, which are great, as to show Karen's angry. But to me, absolutely shows she didn't know what happened. And if she hit him, she didn't know it. But jurors are not going to like those voicemails probably. John, I effing hate you. Playing more clips of I did it. She obviously didn't say that, but that's what he's using the clips to try and say that those are admissions. Data shows he didn't move. One good point was the voicemail says at 12:59, no one knows where you are. And she didn't talk to anybody. Why would she say it like that? If he was with Jen McCabe and whoever, why would she say it like that? I think that's a good question. But again, unanswered questions are not good for the prosecutor. That may have been part of my theme as the defense attorney. Unanswered questions mean they lose. So all this stuff they're going to bring up. Why did Karen say this? Why did that person say that? Why did the taillight break differently? Why did he have no injuries? Where was he actually standing? Where was the car? What time was this at? All of those unanswered questions mean they lose. Because Hank Brennan himself brought up so many unanswered questions. She meant her or the kids. Okay. I think we might be assuming what she meant. I think it was a good argument by Hank Brennan. Doesn't prove what happened, but just a little point I didn't think of. Okay, we're going to jump ahead a little bit.
McCabe, call Jen McCabe. Why is she calling Jen McCabe? She calls Jen McCabe. You know what she doesn't say when she calls Jen McCabe? When did he leave the house?
Great point. So this was some of the better points. Why didn't she say, what time did he leave the house? I dropped him off there. He got out of the car. Why didn't she say that? It's an unanswered question. Definitely doesn't prove she hit him with a car, but it definitely is a suspect unanswered question. The defense does not have to answer questions. The defense does not have to fill holes. The defense does not have to prove anything. That is something the jury really shouldn't forget.
Okay. She calls Jen McCabe. You know what she doesn't say when she calls Jen McCabe? When did he leave the house? What happened last night? No. She calls and says, I left him at the waterfall. See, now it's gone from panic to self-preservation. I left him at the waterfall. And Jen says, left him at the waterfall? He saw you in front of the house. Click. Hangs up. So then she calls someone.
I find it incredibly ineffective when you slap the table at random times like that. It has to really make sense out of passion, not like hang up. I don't find that effective personally. A lot of lawyers do it.
One that she doesn't know very well, she calls Kerry Roberts. But now she has to pivot because someone has seen her in the exact spot that John will be found soon. Whether she's the first one there or somebody else, John will be found. Maybe Lucky missed him. It's a snowstorm. You can't see, but someone's going to find him at some point. So she calls Kerry Roberts. It's no longer she left him at the waterfall. She pivots. And she calls, Kerry. John's dead. I think he got hit by a plow.
Another good point. Why would she think that? Why do
you think she chose those words? Why did she choose those words? Because she knew that there was a collision with a large motor vehicle and she had to substitute her 6,000-pound Lexus for another big vehicle. I think he got hit by a plow. And so now we have the introduction of Jen McCabe and Kerry Roberts. Phone calls that they probably never, ever wanted. A worse nightmare to get a call like that for what's going to happen, what they're going to see, what they'll never be able to forget. But because the defendant is John O'Keefe's girlfriend. They wake up in the middle of the night in a blizzard out of their kindness, their loyalty, their devotion.
And here we go. Now's where he turns the sap on, where any good points he made, it's like, you're going too far now. Too far with these witnesses were not so likable that you can do this with them. Maybe John O'Keefe's mom and niece, but this was tough. Rebecca, watch the podcast tomorrow with my dad. He may agree with you. Not necessarily just specifically with closing, but how Hank Brennan's progression through the defense's case.
To John O'Keefe. And when she calls them and tells them that she wants them to come out, this soccer mom with a perfectly normal life gets drawn into this whole farce. And she answers that call. She gets out of bed. The spirit and kindness she displays to put herself in that position because someone asked for help, because that's what good people do. Kerry Roberts.
Why didn't she go outside that night after John stopped answering texts and Karen's car left? She could have really helped him then.
Didn't know Jen McCabe. They both knew John. They met each other once years before. Kerry Roberts separately at that time answers the call, gets out of bed, drives to go help because they have a common denominator, a common bond. John O'Keefe. And so you hear and see at 5:07, the defendant leaves Meadows. She leaves.
All right. Then he goes into the fact that she didn't crack her taillight on the Traverse, or didn't bust her taillight on the Traverse into 50 pieces. Why was Karen so frantic if she didn't know that he was dead? She knew exactly where he was before anybody could see him. Weird shaped lump. Yeah, right. Glasses from the waterfall. Shoe, hat, straw. He kept saying that. Shoe, hat, straw. All that stuff on the lawn. Totally looks like he was hit by a car. No one ever said he went inside. The body wasn't 20 feet. Show the dash cam. He had glass in his nose. The glass traveled with him. To me, that didn't make a lot of sense. Like, if the glass was in his hand and then ended up in his nose, how did it still end up right, near him? Wouldn't it have gone flying? I don't really know. But some of those things I agree with him. The shoe, the hat, the taillight, you would expect all of that stuff to be right there in the debris field. So if we're allowed to say that, if we're allowed to be with the Commonwealth on that theory that, yeah, that stuff does look like she backed up and hit something and her taillight shattered. Why are we also not allowed to say we look at his body and we would expect him to have certain injuries and he doesn't have those injuries? You need to explain how that's possible, Hank Brennan, and you just ignored it. You can't do that as a prosecutor. You can't do that. So I think it's completely fair for people to say, I would expect a debris field for the cracked taillight. I expect his hat to fly off, maybe his shoe to fly off, the glass to be there, the straw to fly out. I would expect all that. That looks like a collision. But when you look at the body, how do you not have questions for reasonable doubt? That's a question I would have to people respectfully, and I'm being serious. That's a question to the people that the debris field and all the stuff, even, in his sweater, finding the debris, forget about the chain of custody and all those issues. I get it. People maybe don't put credibility into that, but that's the issue is you're looking at something and you expect to see it. You see what you expect and then boom, it totally takes a left turn. Going to jump ahead a little bit here.
She is now coming to terms with the moment. Her fear is realized. She hit him. She clipped him. She didn't think he was mortally wounded. She panicked. She can't come to terms with it, so she has to bring people with her to face it. And now she's facing the reality of what she had done. And her emotion is overwhelming. I hit him. I hit him. She speaks to Miss McLaughlin. I hit him. Not did I hit him? Could I hit him? Perhaps I hit him. That was earlier. Now she's recognizing what she did. I hit him. And these people are making it up.
So he's telling the story based on what he has. Simplifying it, believe a defendant when they tell you they did it. That's a confession. And confessions are the best evidence. We've said it throughout. The fact that he has these statements from the, interviews, he built his theory around it. That was no accident. That was a smart plan. That's the only plan that's ever going to work because of what the science and the medicine show. Thank you, Jennifer, for the super sticker. And yes, everybody hit that like button if you haven't already and subscribe. Amber said it's the Peabodys from CCHS's 50th wedding anniversary today. Can you wish my parents happy anniversary? Happy anniversary to Mr. and Mrs. Peabody. Mrs. Peabody was like the do-it-all at my high school, Calvary Christian High School. That's CCHS. Happy anniversary. 50 years. Wow.
Anybody that says anything adverse or inconsistent or inconvenient is a liar or a perjurer or in on a conspiracy? Or is it that these good people who went there for a total stranger to do their duty to help happen to remember that she admitted what she had done? I know
It's like they happen to remember that. That even his qualification of how they ended up saying later that she admitted to the crime is weak. It's just, that's weak.
that doesn't reconcile with the boogeyman Proctor and the bad government. I know it doesn't reconcile.
The who? Come again? Who's Proctor?
I know that doesn't reconcile with the boogeyman Proctor and the bad government. I know it doesn't reconcile with no DNA on this piece of that piece. I know it doesn't reconcile with everybody setting up the girl. I know that doesn't reconcile. But the reality is you have independent core people who hear her say, I hit him. I hit him.
Independent core people. Who's calling them core people? Are they your core people? So what else is interesting to me about this is it seems like he prepared a lot of this based on what he thought they were going to argue based on trial number one. Because the whole like conspiracy and pin it on the girl and all this stuff, they talked about it. It was definitely part of trial two, but way more a big part of trial one. AJ used science as his unbiased witness. Hank Brennan used historian as his. Wouldn't a historian's testimony by definition be close to hearsay? That's a good point. Ioana. I felt like the Commonwealth put up a good story, and in the second half of the closing reminded us that there's no evidence of the collision. Curious what the jury was left with. Tracy, my first super chat. So many issues, but something I find odd is that Karen Reed's last text to Brian Higgins was John's dead, but no reply from Brian Higgins. Surely he would have replied with some sort of shock if he didn't know. Great coverage, Peter. How can Brennan prove Karen's extrapolated BAC equated to being drunk without knowing when her last drink and several others saw normal driving? He did it backwards to when the last known she was driving. It's not perfect. Like I said, it could have been picked apart a ton if this was a DUI trial. Peter, do you think the jurors see bad faith in all the different charges? Like, what are you trying to prove exactly? Seems like the Commonwealth will take anything. I don't think they see it as bad faith usually. I think they see it as different ways of looking at the same facts. I feel like Hank Brennan spent too much time defending his own witnesses than proving the case. His pacing was a bit distracting for me. Do lawyers walk around to make some jurors make sure they're paying attention? So I'm a little sped up, so it looks like he's walking around faster than he is. It's engaging. Walking around, making eye contact with the jurors is the most engaging way to do an argument, my opinion. Pita, you got to work. Pita, that's horrible. You got to work on your Boston accent. I'm terrible at it. Saying it like it's spelled with a D instead of a T. So Pita, that's how people would say it. I don't know. I need to hear Judge Cannoni say it, I feel like, and then I'll be able to repeat her. Did it bother anybody the way Hank said put slides up and down? Hank's closing was too much back and forth with timing. Alan's demeanor and organization was smoother. Paralegal bias here, thanks to the content. I do think that the structure of Alan Jackson's was better. Okay, I'm going to wait for the verdict form question. Do you think guilty of OWI only that's an easy appeal? I don't know it's an easy appeal. I don't know that it's an easy appeal. Hank Brennan didn't respond to Alan Jackson's hoodie accusations. Would you have responded if you were Hank Brennan? Thanks for the great coverage. No, probably would have ignored it too. I wouldn't have done it in the first place, but I probably wouldn't have ignored it. I probably would have ignored it. Peter, I know you're not guilty based on the evidence as I am, but how certain are you that she did not hit him? I am not so certain. Not certain at all. I don't think there's anything that can be proven based on this horrible investigation. The investigation left unanswered questions, and that means not guilty. Hi, Peter. Can't remember if the defense presented something about Karen Reed going in reverse. Did they? I don't remember them really focusing on that. I wonder if the jury is more swayed to give justice for John because his parents are sitting right behind the prosecutor right now. Lawyers know that's not an accident, I'll say. I'm confused. Did she not mean to hit him, or did she make a decision to get the last word in by speeding backwards, Brennan? You can't have it both ways. Alternative theories there. Alternative theories. As a nurse, science and lack of physical body crash evidence proves not guilty. Thanks, PETA, for covering these two trials for the chat you know. I have a hard time believing anything coming out of Hank Brennan's mouth on this trial. Do you think the jury still finds him believable or reliable? I think that depends juror by juror. All right, let's listen to some more.
And the attempt is to betray everybody. It's a liar. But you don't have to rely just on these good people, although you should. You should. You don't have to, because we have a guide, and it's Karen Reed. Slide 17.
So what I said was, did I have, I always said I didn't, but did I really say this many times as law enforcement's cleaning? I said it.
Okay. I know it doesn't fit the theme, the theory, the story.
Those interviews are trouble. They're trouble. If she gets convicted, there's no doubt that's Exhibit 1A.
She tells you herself. She endorses those good people exactly what they had heard. She tells you herself. She hit them. It's undeniable. It's unmistakable. It's inconvenient. But the truth has a way of seeping up to the daylight. It can be oppressed and suppressed and pushed down and covered and twisted, but it rises. It rises. And it is not a coincidence. There's no coincidence that Mr. Nuttall and Ms. McLaughlin hear exactly that. She tells you. And Jen McCabe, when she's sitting next to or standing next to Ms. McLaughlin, she tells you that she saw or heard the same thing. Remember what happened to her on the stand when she had the audacity to say, I heard her say it? What happened to her? This woman who never even wanted to leave her home that day, pulled out into a storm to see her best friend dead. What happened when she had the audacity to say that? And now we know that the defendant herself said the same thing. And the funny thing, ironic thing is, you will see in a photo when Ms. McLaughlin, firefighter, was speaking to the defendant, Ms. McCabe was next to her. Ms. McCabe was trying to protect her, trying to shut her up. Don't talk, you're upset, stop saying crazy things. The villain of the story was trying to help the defendant.
I don't feel like Jen McCabe came off as the villain of the story this trial. Again, that felt more like last trial. So is the jury sitting there like, what? Why are you saying like conspiracy? Why are you saying the villain of the story? Why would Jen McCabe be the villain of the story? I guess the house long to die in the cold, but I don't know. That's interesting.
From incriminating herself. The irony. Can we have slide 9, please? This is the battery temperature. You're going to have a chance to look at it.
Yeah, I would agree. Proctor felt like the villain this trial. Peter, are attorneys friendly after court cases, aka the defense and the prosecutor? My dad has a good story about that this week on the podcast. Yes, very friendly. I have hired people that are former prosecutors, literally, that we're prosecuting cases against. We've hired them in our firm.
And it wasn't so tragic. It is interesting. It is interesting if you like data. The 29, 12, 13, they're leaving the waterfall 82 degrees, 12:22, into the car, 77 degrees, 12:37, about 3.5 minutes after the defendant.
So this is him again. Both of them tried to use the battery temperature. I'm not sure how effective it is because I don't know exactly how fast it should go up or down. If it's in somebody's pocket, inside, outside, in the snow, I don't know.
Aligns with John O'Keefe. It started to go down 72, 12:45, 66, 12:53, 61, and you see it drop and steady off at 12 or 1:36. Remember, cell phone battery under him. John O'Keefe either struggling for life or he's passed, and the blood's still warm either way under him. Doesn't move again until 6:06. It drops down 7 degrees because the women are pulling on him. The cold air is hitting the battery. What happens at 6:15? You're going to see the video. You've seen it. Still photos. Carrie Roberts goes over, takes up the phone. Not only does she pick up the phone, she puts it in her pocket, and then 20 minutes later, the next meeting, the temperature rises. That's not convenient. That's not a coincidence. That's fact. That's data. And then the phone is passed with a warm environment, and it raises up. 6:15. How can someone conspire to pick up a phone on the side of the yard that's under Mr. O'Keefe's body at 6:15 and know the battery temperature was then going to rise? Not only did the battery temperature rise, when you look at the healthcare data, at 6:15 when she picks up the phone, you know what happens to the healthcare data, right? It starts to move. It's data. It's data. So, while they're going through this duress, the defendant asked Jen McCabe for yet another favor. Look up hypothermia. Find out how long it takes for someone to die in a cold. And there's Ms. McCabe in her winter jacket, soccer mom, trying to help. She has MS. Her hands aren't working. She's trying to type it in.
Soccer mom with MS. She's just a soccer mom with MS. It was a little strange the way that he talked about Jen McCabe to me.
What's happening during that
Oh,
time?
yeah, that's a good point. Thank you. See, you guys are the best. During the trial, he showed a clip of Karen Reed saying it's either you or me, Jen. That was weird. He brought it up. No, I agree with you. You're right. He did play that. That's a good point. Man, I forgot. Hopefully the jury remembers, I guess, from his perspective.
It's a frantic scene. She tells you that. The defendant then wants to run back to the ambulance, so she goes with her, never finishes or completes the input. And then she tries it again at 6:23, at 6:24. That's what this.
And again, KCD, I agree. The hard part, though, in a trial like this is you have that simple way of explaining it. You also have the simple way of explaining how horrible the investigation is, so we won't know what's happening. You also have the simple way of explaining it. They can't answer any of these questions about what happened. There's a bunch of different major defenses that would be, I think, a successful defense in lots of normal cases.
Woman did that night, that morning. Not only for a friend, for her. That's what she did. And what happens to her after? Because the timestamp, when you open the timestamp, it's at the time it's open, and she's in bed at 2:27 looking up Hawkmark Sports because she is so interested in the kids' sports, and that timestamp stays open. And she goes to that tab the next morning when she puts in how long to die in cold. And that's being portrayed that she's in a conspiracy. She gets vilified.
Again, I think the fact that the defense did not go full in on the conspiracy may make the jury think this weird. They definitely said stuff like, they wanted to pin it on the girl, and they were going to make sure the girl, she's effed, and the only people named McCabe, Albert, and Higgins or whatever were on certain text chains and certain conversations. But I mean, he is almost highlighting it as much as they did. Because I think he knows 30 people, including all these different people from different walks of life that didn't really know each other that well that night, being in a conspiracy is hard to believe. But the defense focused on so much more than that, on all the reasonable doubt, which I think was just better. Rebecca, are they deliberating today? No, they'll be back Monday. Michelle, what did you think about Hank Brennan walking over to Karen? Very common for prosecutors to do. They find it effective and they're tough. They're going to, as a young prosecutor, when I came in, I couldn't wait to do that. But there were some people in kind of like my class as externs at the prosecutor's office that didn't want to look the defendant in the eye and point to them. So you got to learn how to do that, but prosecutors usually love doing that.
Her, the soccer mom, who came to help. It took Ian Whiffen 5 minutes to show you a live demonstration on how simple that works. That she's not deleting anything. Jessica Hyde told you it's automatic deletions over time. You usually can't delete that information. That's not a click and swipe like the good Dr. Wolf from Arca knows how to do. This can't be erased. But they still hold on to this. As they argue to you and all the injustices that have been done, they tell you, they want you to believe, or take a flyer on the fact that she looked up how long to die in the cold at 2:27. It is an absolute contrary to the science. There's no basis to support it, but they stand here in front of you. Why? Because every time they say something like that, you look the other way. Don't look at her. Look the other way. 2:27. Look the other way. Don't look at what she did. Former.
And again, that's what a lot of people pointed to. That was exactly kind of what Alan Jackson did at one point in the closing of the first trial. So I don't know. I don't know if he studied it. I don't know if that was his plan, but it didn't seem overly effective to me. Kelly, I definitely think Hank is a good lawyer, but I don't get why he would take this case unless for the money. No way he thinks she's guilty beyond a reasonable doubt. So I'll tell you two things. Number one, I'm pretty confident. I don't know his life, and I don't like to count other people's dollars. But if you are a superstar lawyer doing criminal defense and personal injury, you make more money doing your practice than doing what he did over the time period that he's handled this case. Okay. You should make more money, I should say. Not everybody does, but I'm just saying, I don't think it was for the money is my point. I don't think he got some huge, big boost in money to handle this case. But I think people are underestimating how criminal defendants in the future will look at the fact that he prosecuted this high profile case, regardless of if he wins or loses. I think he will get more business because of this. That's my opinion. Feel free to disagree with it. I know that you will. That's just my opinion. But I'm just a civil lawyer.
Trooper Proctor, look the other way. Don't look at her. Every time they make those, she got the glass from inside the Albert, maybe in the basement. Look the other way. Don't look the other way. Look at the facts. Look at the data. And it all leads to one person. There's no grand conspiracy. It leads to one person, the defendant. And it's not just the data and facts. It's her herself. Let's talk about Mr. Proctor. You were invoked with this emotion early in the opening that this is a cancer. That's a tough word. Trying to evoke that primal reaction discussed.
He does stuff like that too, where he tries to call out and highlight lawyer strategy. It's Oh, he used cancer. That's a tough word. It's like, so is death and killing of an officer. Like, a lot of tough words being used in this trial. He's like, he's just trying to trick you and pull a reaction out of you. It's like, no, Proctor's probably worse than cancer for Karen Read. Maybe that's hyperbolic. I don't know. But like, he is ruining her life like cancer ruins people's lives. That's the defense's theory, at least.
I'm not saying you shouldn't be disgusted by the text messages. You should. I'm sure they're not defensible. I don't stand here and defend impropriety. I don't. But that doesn't change the physical evidence, the scientific evidence, and the data. He was terminated. He paid a penalty. He was held responsible for what he did. He should have been. He should have been. But that doesn't get a free pass. That doesn't change the facts. It doesn't change the physical evidence. It doesn't change the science. It's unfortunate. It's distasteful. It's dishonorable. Remember, the Trooper Lieutenant was asked, was the investigation with honor and integrity? And he said it was. Was Trooper Proctor's effort honor and integrity? And he said it was integrity. But he never said honor. That's a man of honor. Military service, dedicated to his country, highest level of clearances to the president.
It's tough, man, when you got to go to bat for some of these guys.
In the United States, now a state trooper, he would not say that Trooper Proctor was honorable. Because he wasn't. He wasn't, but that does not change.
He's admitting it, right? He's throwing Proctor under the bus and kicking him too. But he says we didn't need him.
Create a conspiracy, doesn't invent a dog. It doesn't make somebody in a house something they're not. It just doesn't. When you read those text messages, they're hard to look at. It's unfair. It's unfair. And if there's a penalty more than being fired, well, maybe that penalty would be deserved. But it has nothing to do with the justice in this case. It just doesn't. There's not one piece of evidence, not one, that we can look at and say, this was tampered with. This was planted. This was distorted. Remember when we introduced the taillights at the beginning? I didn't introduce 3 of the taillights, but then the defense did, so I put them in. Those were taillights that were only found by Trooper Proctor. I did not put that evidence in. Understanding those text messages and appreciating the disdain one might have for his comments.
Did you hear that? He's like, I wasn't even going to put in some of the stuff Proctor found. It's like, dude, you cannot do that because Proctor found everything and tested and interviewed all of these witnesses. But he's acting like I knew Proctor was so bad too that I didn't want to put in certain things that just he found. What? That's brutal. That's a brutal admission by Hank Brennan.
Not that there's any evidence of tampering. Not that there's any evidence that it was not
It's
true.
like, not that there was anything wrong with the taillight Proctor found. There was definitely not anything wrong with it. I just chose not to put it in. We're going to back it up to let's do it again.
This was distorted. Remember when we introduced the taillights at the beginning? I didn't introduce 3 of the taillights, but then the defense did, so I put them in.
I didn't introduce 3 of them because I didn't feel like they were that important because Proctor found them. But there's no problem with them. It's like, if there's no problem with those taillights, why would you not put them in, sir? If it didn't matter, if Proctor's text messages and his despicable behavior didn't matter, why would you not put the taillights in? I don't get that.
Those were taillights that were only found by Trooper Proctor. I did not put that evidence in.
Why? Should we not trust evidence only found by Trooper Proctor, sir? Is that what you're telling me? Should we not trust evidence that only Trooper Proctor found? Please. Whew.
Understanding those text messages and appreciating the disdain one might have for his comments. Not that there's any evidence of tampering. Not that there.
So the disdain for his comments are the reason you didn't put the evidence in, but you're telling us just trust all the other stuff.
There's any evidence that it was not true. But I didn't put that evidence before you because we didn't need Trooper Proctor in this case. We don't need Trooper Proctor to prove this case beyond a reasonable doubt. That's why I didn't introduce that evidence to you. Now, there's been a lot of talk about planting of taillight. We know the taillight.
What a transition. Hank Brennan is purposeful in his transitions. That's why he was like, you work for insurance companies, don't you? Dr. Wolf, or was it Wolf or Wenchler? I think it was Wolf. He's like, you work for insurance companies. Now let's talk about that other party that hired you, right? He follows those questions up to try and make the jury connect those dots. He did it here, but the opposite. He's like, I didn't present those taillights to you. All right, now let's talk about, there's been a lot of talk about planting of evidence in taillights in this case. It's like, not the transition I would go for there.
It wasn't planted because talk about planting of taillight. We know the taillight wasn't planted because Trooper Buchanan and Mr. Proctor did not go down to Dighton to see Miss Reed until later in the afternoon. We know from the 507 video, we've seen that. We know the taillight was already missing when she's leaving the driveway. When the good Canton police detectives went to do a wellness check to care for those young children, and they went to the house inadvertently, they didn't even know it. The dash cam captured the back of the car. The taillight packed with snow is missing. It's already gone. It can't be planted. At this point, Trooper Proctor's still in his pajamas. He's not even on the case. He's not even on the scene. He hasn't been near the car. And then the Dighton videos themselves, when you close, you can take it at an angle and it moves, but if you get the right angle, you can see it's missing. It's gone. Can we have slide 18, please?
If you get the right angle, again, just me. Every juror is going to be different. If I was a juror, that the pictures and videos of the taillight, not overly effective to me for either side.
507. You can play anything you want. If you look at this angle, it's gone. There should be no plant. It's already gone. You know where it is? 34 Fairview Road, on at the Reedfield. January 29th, 2022, page 23. Look at the right-hand side. Look at the left-hand side. It's packed with snow. It's gone. It's gone. And the same thing, when you lose the videos, it's a different angle, a little smaller. If you play that and watch the lights go up and down and slow it down, you'll see it expands. It's gone. So when you have Dighton Officer Barrows come in here and try to tell you what he saw in the salad bar, couldn't have been it. You got to ask.
So now we get to him trying to go at Barrows' credibility here.
Yourself, what interest does he have coming in here in this case? A lot of attention on this case, a lot of people watching. Comes in after, of course, driving all the way out to the defense attorney's hotel to meet in a conference room so he can get a subpoena. He spends 2 hours driving up and back so that he can conveniently get a subpoena that tells him to appear, which he could have got by fax or in the mail. And so when he comes in, what he says is, that's absolutely not what I saw. Absolutely not. And then he claims at the last time he testified, he had made the same statement. I showed him his transcript. And did you see the redness creep over his face? He never said this before. In fact, he testified to the opposite.
So that's how he went. Every lawyer is going to attack the credibility, especially when it kind of worked when they were on the stand. Brussels Spout said, Hank also mentioned planted evidence in his closing and also asked Dr. R about planted evidence when the defense didn't really go that route, found it weird to mention that if it wasn't needed. So here's what I'll tell you. And this happens, especially in longer trials for me sometimes. Actually, it was important in mock trial because when I was in mock trial in law school, you practice so many times. And the answers for the witness are a little different every time. So your closing's a little different. So some people, I would love it. I would, because I'm like a psycho. So I would like memorize the packet basically. And if they would argue in closing something that they had practiced and memorized that didn't come out in the actual mock trial in the competition, I would object to facts not in evidence and it would shake them. But you have to pay attention to what comes out in this case. In some longer cases and trials now, it's hard because you do all these depositions and somebody says something in deposition and you know they said it and you plan your case on it. But does it actually come out in trial? You can only argue things that come out in trial. So I'm wondering if Hank Brennan kind of was like morphing these two trials together of how he thought it was going to go versus how it actually went.
And so he sits on the stand with a new story after a meeting. We don't know why, but then I show him that bottom right photo with the snow, with it missing. And I say, is this the way it looked? That's of course before the snow melts out in the salad port so that you can see it unexposed. And he says, yes, he had to agree. This taillight was gone. There's no boogeyman. There's no plant. There's no Higgins at the salad port. There's no one tearing out pieces. In fact, remember I played you a clip and you'll have it where the defendant says, I was picking out pieces. It was crashed in. The bulb was showing, showing Terry and Jen when they went back to Meadows. If you don't remember, listen to that clip. You'll hear it. Unfortunately, there's no ring video when they go back to Meadows. There's a ring video when she leaves. There's no ring video when she gets back. And so now when we're trying to look the other way, we want to find a dog bite. So enter Dr. Russell. Dr. Russell, according to her, nice woman, nice doctor, very accomplished. I respect that. She's the only dog expert in the world. The thing is, we know no idea what that expertise means. She volunteers for the job. She wants to be here. Just on her profile, but she can't explain methodology. What are you looking for in a dog bite? She can't tell us. It starts a year ago that it's claws, it's teeth, and then it's claws, then it's teeth, and then it's I don't know. And then when you look at each of the different parts of the abrasions, she says, well, I can't tell if I look at each one of them, but all together it's a dog bite. It's a dog attack. That is the masterful expertise that the defense has bragged about bringing in. Dr. Russell telling you, because she says this is a dog bite. She has never been in a forensic situation where she's looked at a...
I got to be honest. He ignored certain weaknesses. This is one I would have also ignored. I would have stuck with Taillights all over the yard. No doubt there was a collision. Look at his arm. It looks like it was scratched by a taillight. I would have just stuck to the conclusory statements, because going after Russell, you have to realize these jurors are normal people. They're not like investigating experts all day, every day, like lawyers. I just spit everywhere. So acting like she has no expertise and is just like, eye roll, that didn't hit well from my perspective. After a deep dive into the pro-Commonwealth channels, unfortunately, the Commonwealth supporters do not look at the evidence. It only takes one juror to actually believe Hank. What would a third trial look like? Thanks, Peter. I think it would be more similar to this trial. I think this was much better for the defense. I don't know about the prosecutor. I think they could get a new prosecutor and they could kind of come up with some new theories. I don't know. I feel like he's trying to go for a mistrial. I mean, listen, you would much rather a hung jury than a not guilty verdict if you're Hank Brennan, but I think he's trying to win. I do think he's trying to win. One question: is it not up to the defense to prove she didn't hit him? Absolutely not. If her taillight did not get smashed in the driveway, she did not hit John O'Keefe, where did she break her taillight? Did she hit something else on the same night? They do not have to prove that at all. The Commonwealth has to prove the taillight hit John O'Keefe in the arm, scratched him, knocked him down, killed him. This is an important question, because if you get it twisted, our whole criminal justice system flips on its head. Bethany, he never mentioned his screw up with the hoodie cuts that he so egregiously tried to lie about to the jury. AJ said he wouldn't mention it and he didn't. That's hard to ignore in summation. Did he not want to clear his name? I think that's a rhetorical question.
The wound and identified it as a dog bite before. This is the first time, the only time she's ever done it. And what she says is these are not punctures. Punctures means it goes into the skin, a wound. There's no punctures. And she's sure because she's an expert, so you should rely on her because she's coming in saying she's an expert and she's being presented. Yet, after saying there's no punctures, Dr. LaPosada comes in and she sees punctures everywhere. It's an animal attack. It's a dog. Oh, is it? No method, no methodology.
He just made it sound like LaPosada said it was a dog too. More consistency.
No history of this, no prior testimony that we know of other than arbitrarily what she says. And she says the exact opposite of Dr. Russell.
No other testimony except arbitrarily what she says. It's like, isn't that like every expert's testimony, arbitrarily what they say? I get methodology and science and whatever, but when you come and testify, you're just talking.
Why is that? How does that happen? So obviously, there is no science to looking at an abrasion and saying where it came from. They give us no detail. They give us nothing that we should rely on. They contradict each other. It's just to get you to look the other way. And so we have now the issue of the defense has said over and over again, there's no collision. There's no collision. There's no collision. And they had a number of witnesses come in to try to say that. And they point to Dr. Scotty Bello, who works at the medical examiner's office. She tells you that she doesn't see injuries consistent with a collision. She's looking at this case for 90 days. 90 days. The evidence in this case did not stop. It continued for 2 years. She knows nothing about the data, nothing about the black box.
Yet she still came at trial and testified inconsistent with a car accident. He's trying to hit at some of these reasonable doubts, but some people are asking me, like, how would you respond to this stuff? It's like, it's really hard because some of it is really tough to respond to. That's the point. That's why I see this case the way that I do. I'm not saying it's easy. I'm not saying that's where I wanted to end up. We watch these cases, we see the presentation of the evidence, and then we end up where we end up. It's just how it is.
Nothing about the interviews of Miss Reed. She doesn't know about the DNA. She doesn't know about the shards in the arm or in the clothes. Strike that in the clothes. She knows nothing about that.
She doesn't care. It would not matter. I promise you, Dr. Scorty Bello couldn't care less about the debris in John O'Keefe's sweater. She is x-raying, opening him up, looking for lower extremity injuries and finds none. Therefore, she's like, I can't say it was a car accident.
So in 90 days, she didn't see any lower body injuries. She didn't see any lower extremity injuries, which are very common in car collisions. But that doesn't mean it didn't happen because she, in 90 days, saw a fraction of the information, a fraction. And we know now, argument back and forth for days about lower body injuries, the suggestion is a car accident can affect everybody differently depending on the angle, the scope, the speed. Some people can get plowed over by a car and have no injuries. Some people can get touched lightly and have more injuries. And there was the debate about no lower body injuries. Well, ARCA dispelled that in their dummy test that you can have a collision with no lower body injuries.
Why don't you show us Welcher's test case? Put that up there. Remember, your expert brought us in a test case to explain to us how, it's exactly good for your side. Why don't you show us that? Throw that up on the screen. Explain that to us.
Did that for us. Thank you. And so the idea that at the time in 90 days that she doesn't have enough information to say consistent with a car accident doesn't mean there's no car accident. Let me talk a little bit about ARCA. I don't want to waste too much time with them. What?
I don't want to waste too much time with them. Was that like a subtle shot at ARCA?
Expert who's supposed to come to you. They're not. Your common sense has more value than an expert's opinion. Their job is to assist you, to explain what their expertise is so that it's a tool for you so that you can make a decision. That's objectivity. We've heard words like confirmation bias, objectivity. Mr. Wolf got on the stand. And before we even started, you have to ask yourself, what expert has a court order for text messages and then deletes the text messages? What expert? What objective expert?
See, that was not true. So some people he said has a court order, then deletes the text messages. That's absolutely not what happened. Text messages were deleted before the court ordered them to produce their text messages.
Uses signal, an encrypted app to communicate about the case. Never used it before, hasn't used it since. And so when he did his tests, he used a lower weight arm. Wasn't trying to bash him, wasn't trying to insult him, tried to get him just to recognize that a 9.38 pound arm is less weight than John O'Keefe's metric, which would be 11.8. That's all. And because the lighter arm, it takes more speed to create the same damage. I don't know science, I don't know math very well, but that's basic. It's basic. And he fought me over and over again. Did he seem objective that he was trying to help you? Because Dr. Rensselaer came in the next day and said, well, you have to adjust for that. That's all I asked him for an hour about adjusting, just like Judge Welter adjusted. So you adjust it. And he tried to talk to me like I was making something up. His own colleague had to admit it. Now, it's funny, he admitted it before he got through his credentials. No sequestration order violations. Nobody was coaching him, but he knew enough to come in at the beginning and get right on that point.
And I thought that was a missed opportunity for Brennan to go in on what he was trying to pull out of every witness, that the defense was coaching him, threatening him with perjury, telling him what to say, but he didn't.
And speaking of sequestration, remember Dr. Russell on her limo ride over? If Brennan asks you a question, make sure you ask for a transcript. Impede the progress. Slow.
It's like asking for a transfer because you were saying stuff that was not. That he picked the weakest one of those impeachment situations.
Down questioning. Interfere. Sequestration orders is so there's fundamental fairness for all witnesses, not just some. And so what happens with Dr. Rensselaer, we don't know, but we do know he comes in here and he tells you that he was not getting information that was helping him the last time he testified. He insisted. I asked him 5 times, was he getting information that would help him in his testimony? Not from the defense, from his former employer. He said, no, no, no. And at the end of the examination, he reads his transcript and it's yes, yes, yes. And he tells.
It was hardly that clean. Hardly that clean. Why wasn't there a second trig for KR slamming into drive and flying away? Why so casual drive away? Unanswered question, sir. Unanswered question. Peter, do you think the jury might be confused by the verdict slip? Also, I can't believe the ham sandwich made it into Hank's clothing. We're going to look at the jury slip here in a second. Clear, plain, strong indication that the car hit at 24 miles an hour and not a bruise. Don't think Hank Brennan should have said 24 miles an hour, 6,000 pounds, fast or heavy, okay. Don't remind the jury of specifics in this case. I mean, that's the point, is he wants to use, just like this sequestration order violation with Rensselaer, he gets to use the FBI against Rensselaer, but the defense doesn't get to use him for it. This time the jury has lower DUI. That may be guilty on that. And if people use reasonable doubt, the rest would be not guilty. Could be. Is that part of the defense's strategy? You can't use assumed inferences, unanswered questions, and inconsistent or reliable witnesses' testimony to defend a proof is in the data thesis. So you're allowed to use reasonable inferences to make your arguments, but as the jurors look at it, it's different. Question, if they were to deliberate yesterday within an hour, say, don't you think Bev would have called a mistrial saying they were too quick to conclude? No, I don't. We just saw it in Lori Vallow's case. Question, what if there's a surgeon or a reconstructionist on the jury? I know they don't have more weight, but how do they ignore their knowledge? Oh, they'll have more weight. And you go back there, if you're like, I'm a surgeon, that ain't what it looks like. Most of the jurors are going to be like, oh crap, really? When somebody has that expertise on the jury, usually it does hold a lot of weight. How did JOK end up face down when he fell backwards and was incapacitated? A lot of people have asked me this. It wasn't fleshed out enough on how he was actually found. Did Hank Brennan say he was found prone? I think on 911 call, McCabe said she turned him over. How did he end up face down if he fell backwards? I don't know. Again, I don't know. Peter, from your experience talking to jurors, has anyone ever said they regret their verdict after knowing what actually happened outside of court? No, I've never had anybody tell me that. But I would be interested to continue to ask. If they thought he was hit by a vehicle, why didn't they try to rule a snowplow out by interviewing Lucky immediately? Well, I think we know the answer to that. The girl's going to catch serious charges. She's effed. Something stinks. I just can't understand how J.O.'s parents don't wonder more about what happened. Maybe they do. A lot of times victims' families get entrenched in wanting justice, starting to get confident and just feeling better about getting closure that way. Honest thought, was Hank Brennan's ego alone enough to turn jury to not guilty? If not, then what are we thinking after both closing statements? It's tough for me to say, like, that wouldn't bother me as a lawyer, like his ego or, I'm using air quotes, or his demeanor. From my perspective, I'm thinking the defense did their job in highlighting all the reasonable doubts. The prosecution did not do their job in eliminating all those and proving the case. They did a good job of making me wonder, like, is Karen Reed's theory real? Is this really Brian Higgins? Did she really not know what happened? Was she trying to, misdirect? He had me asking some of those questions as a good defense attorney would. He just didn't do his job as a prosecutor proving this case to me. Verdict form question, we'll hold that one. Will Brennan be sanctioned after the trial? No. Will AJ have sanctions for the grave concern issue? No. Thoughts on the verdict slip? We'll get there. Confusing still, in my opinion. The defense add OUI to avoid another mistrial. I think they would much rather have a guilty verdict on the OUI alone than a mistrial. That's just my guess. Not talking to anybody on the defense team or the prosecutor team. That's just my guess. Can the jury have access to transcripts? No, they do not. What about the missing footage from the library, which would have shown the taillights, but 2 minutes conveniently missing? A little sus. New subscriber? A lot of sus in this case. Why was Yuri at the courthouse? Is that normal? It's not abnormal for the lead case agent or lead investigator, if that's what he is now, to be there. It's not that abnormal. Most of the defense team have their backs to Hank Brennan, with only Miss Little watching him at times. In your experience, what's going through the minds of the defense attorneys during this closing? Thanks. When I do closing after I'm done, and I know they're up there and I can't go again, I'm just, looking at something working. I'm not really watching them. You can call it disrespectful. It's an adrenaline come down because you put everything into your closing, the whole case in summation. I'm not usually like sitting there intently watching personally. Peter, these closings are a counterpoint to your argument that it's better to give closings from memory. AJ was clear and organized. HB rambled and buried the important info in his vitriol. Happy Father's Day. Here's what I'll say. Can definitely go wrong, right? But I think a great closing, beginning, middle, end, structured without notes is still the gold standard. But you would not want to sacrifice clarity for no notes. As a lawyer, during jury selection, how much are you eliciting information for the purpose of crafting your arguments and closing? A lot for me, a lot. Rebecca, one thing that's hard for me is knowing medicine and how things Hank Brennan tries to make a point regardless of who did what to whom. Honorable man, dead, legacy will forever be tainted by this circus investigation. Sadly, he will never receive justice. And if you're back there, Rebecca, working from the ER, they'd be like, well, is this what you'd expect it to look like? They would ask. They like to know people that have the expertise. Silly question, but why attorneys prefer a hung jury to not guilty? I meant the prosecutor. The prosecutor prefers a hung jury over not guilty. Not guilty means you lost and it's over. Hung jury means maybe you get another chance. You get to save face when you walk out there and say, we proved it. Thoughts on Hank Brennan just sitting down at the end? He never seems to acknowledge the jury and their role over the last 8 weeks and now. Sometimes that can come off as corny. I also didn't really know he was done when he sat down, so it was kind of a little bit weird. All right, let's listen to the last couple minutes of his closing. This is how he's bringing it home.
Tells us that he's independent, objective. I asked him about a lunch, and not a big deal. Just ask him about it. And he says, I have a sandwich, and I stand in the corner until I remind him that we got video footage from a documentarian, and he's in one of the scenes. And then things change. So when you talk about objectivity, they can come in and say, Judge Welcher said this and that. It doesn't make it so. Judge Welcher, Dr. Welcher, never in any report, in any presentation, in any testimony to you, ever suggested this is how it happened. This was how his arm was. This is how his feet was. He was trying to show whether or not the orientation. Could this happen with the angle, with the height? That's all that test was. It was no more. But what they do is they reposture it.
Well, that's not really what he wouldn't really agree to that when Rentschler was on the stand, that's all he was trying to prove. But what if you were doing that? That yes, it's possible for this to happen with the height. Why didn't you do the other possibilities? Is it possible for an arm to destroy the taillight like that? Is it possible for the arm to get cut like that? Is it possible for the arm to get cut and not bruised like that? Is it possible for the arm to get cut, not bruised, not broken? Cut, not bruised, not broken, and destroy the taillight? Why did you not go through all those possibilities?
Repackage it and say it means this when it doesn't, and we're going to show you why it's not that, therefore we win. That's all that is. It's semantics. Dr. Welcher never suggested that. And his work on text stream data, unassailable. And so what we have, inevitably, is we have a timeline that never moves, data that never changes, physical evidence that can't be put in that spot without a collision. We have, inevitably...
Again, back to the exploded taillight, couldn't be there without a collision. Meg R. Hank Brennan said, Mr. Keefe, Shannon Welcher, accuracy lends to trust. And I think Hank Brennan has some credibility there. As much as this closing isn't evidence, how important is it from your perspective? To me, it wouldn't be a big deal. But I know to some jurors it would.
Proof, without any doubt, that on January 29, 2022, Ms. Reed was with Mr. O'Keefe and she got drunk. She drank. She was 2 to 3 times over the legal limit. And they went to a party, an after party, and they were fighting. It was a relationship in decline.
He started with John O'Keefe, drunk, they were fighting. He ends with John O'Keefe being a good man, drunk, or Karen Reed was drunk, and they were fighting. So the beginning and the end, clearly what he felt were his strongest points.
And he got out of the car, and he had a brief window of life left. And when he got out, and she drove away, she couldn't let it go. She got drunk, she hit him, she left him to die. It's that simple.
Told you. He wants to simplify it. That's the way you win if you're him. Because to look into the details is very difficult. Our lawyers are able to tell if jurors are with them only if they give it away with their facial expressions or while you're giving arguments. But I will say I've lost a case where jurors were like nodding with me and smiling at me during closing arguments. But as a criminal defense attorney, like I said, you lose a lot. We won some huge ones, right? You win some huge ones, and when you win, it just feels amazing and it's crazy. Especially me and my dad have won a couple federal criminal cases where they win like 99% of the time. And it's crazy. Even the prosecutors after came up and they're like, it's a good win. How can Hank Brennan be allowed to lie about facts? For example, when the texts were deleted versus when they got order produced. I mean, it's a nuance. Just the way he said it was technically not true. I'm not sure anybody would say, oh, that's a complete lie. I get what you're saying, though. I know you can be subjective in closing, but can you blatantly lie? No, you're not supposed to blatantly lie. Brandon saying that Russell and La Posada disagreed on the dog bite. Yeah, that's like an inference and more of a twist than a lie, which a lot of lawyers do. It's a way of looking at it, finding one little difference and making it seem like a big difference. Peta, have you ever been to Mass? Yes, I have. Me and Whitney go to like big cities sometimes, just her and I as like date trips for long weekends, and Massachusetts was one of the ones we did. We loved it. We went to a Red Sox game. We did all the like walking tours. We did all sorts of stuff. It was awesome. Went to Harvard Law School. It's hard. You should go. My dad's Sicilian family settled and lived in Boston, so we used to visit there every summer. Emmy only had 90 days, but Proctor solved it in 12 hours. Now, that's a great point, the dusty truth.
We don't know exactly how this collision happened, but we have a good idea from the physical evidence, and we know that it happened. Can someone have a collision without lower body injuries? Can I have slide 19, please? You bet they can. We don't know if this is the body.
And it's always a lawyer's skill when you can use the other side's expert or evidence against them. Both lawyers did that.
We don't know if this is the exact speed, but what it tells us, this is viable. Look at the debris field. Look at his turn. Remember his sneaker on that curve? They got lodged against the sneaker. Mr. O'Keefe then falls back, hits his head, count the coupe, left to die.
And again, we said that. Was that going to be a risk? That the jury can now visualize this is possible. This is how it could have happened with this experiment. It did a lot of good, but if you're a good lawyer, you can find a way to make an argument for you too.
Thank you. Ladies and gentlemen, there is no doubt what happened that night. There is no doubt who did it. You have a very difficult task ahead of you when you consider the evidence and you consider the law. Very difficult. There are 3 charges. There is second-degree murder. Ms. Reed, when she chose to drive back at Mr. O'Keefe in that night with a 6,000-pound Lexus. In that anger, 75%, whether she meant to hit him or not, didn't mean to kill him, she hit him. Straight, it is a plain and strong likelihood of death. You would never get back down your driveway if your kids were at the end of the driveway. You would say, "What, are you going to kill somebody?" You would never do it because you would expect, if you drove at them at that speed, that someone would die that second.
I also think like a million people drive backwards fast and don't think somebody's going to die. But I don't know. The more he explains it, the less likely second degree is. First I heard of this case was media. Karen Reed on video thought, dang, that sucks. But there was no video. Who told the first lie? Saw the arm in the SUV, game over, no collision. It's a good question. That's a good question. I wasn't on it from the jump. So a lot of people have that question. Since the defense asked for DUI, could they still appeal if she was convicted? Yes, there's still appellate issues if she's convicted of DUI. They couldn't appeal the fact that the DUI was listed as a lesser included because they asked for that. So they waived just that issue. Not just the civil lawyer. You help families find justice through the civil process, which may be the only way for the family. I was not apologizing for being a civil lawyer. I absolutely love what I do. I chose it. I respect it. I think it is the absolute best place to be. Helping people do what they can't do. It's impossible for them to do. The victims truly victimized by people's wrongdoings, by no wrong of anything that they did on their own. They don't deserve to be there. They did nothing to be there. And now they're stuck and need a way out and don't know how to get there. I love it. Absolutely love it. I will never apologize for being a civil lawyer. I think it's funny that people use that as a cut. J.O.'s parents still backing cops and hoping Karen goes down. Do you have a theory as to why? I think I might. I think it's because they believe it. They want to believe it. They want to get justice. They want closure. That's my guess. Is it weird, Massachusetts, that the defense goes first in closing? Absolutely weird to me. Really weird to me. Question: if the jury convicts and gives interviews after saying that it was because the defendant didn't prove something, burden shifting, is there something that can be done? Can probably be a part of the appellate process, but usually that's probably not going to be enough. But we'll see.
Rape her. OUI manslaughter. She's drunk. She's reckless. She doesn't have to know she hit him. She doesn't even have to know she hit him. But she did. She did. And she left a man who was kind and generous and thoughtful. She left him alone. She left him alone to die. Could I have slide 22, please? He is not an it. John O'Keefe is not a body. John O'Keefe is not a buffalo on a prairie. John O'Keefe was a person, and he was murdered by Karen Reed.
Take it. Thank you. All right, jurors.
All right, so that's it. So now I'm going to take a second and I'm going to pull up the jury instructions. We're going to take a look at those. And then we're going to just listen to Canoni read one instruction about these jury instructions. So first, if you can't read it, don't worry. I'm going to read it. Verdict slip, offense 1, murder in the second degree. In the above style case, we, the jury, find the defendant is, or say that the defendant is 1, not guilty, 2, guilty of offense as charged. Okay? That's number 1. That's simple. I'm going to jump to number 3. Offense 3, leaving the scene of an accident resulting in death. In the above style case, we, the jury, say the defendant is 1, not guilty, 2, guilty of the offense as charged. Leaving the scene of an accident resulting in death. That's count 3. Simple. Now let's get to count 2, the complicated one. Offense 2, manslaughter while operating a motor vehicle under the influence of liquor. 1, not guilty of the offense charged or any lesser included. 2, guilty of offense as charged, manslaughter while operating a vehicle under the influence of liquor. Manslaughter while operating a vehicle under the influence of liquor, and or manslaughter operating while operating a motor vehicle with a blood alcohol level of above 0.08. So those are the 2 options under that main charge. Guilty of a lesser included offense, first, involuntary manslaughter. Guilty of a lesser included offense, motor vehicle homicide. And then again, you have to do and this is again the OUI or DUI version. Which way was she DUI? Was she under the influence of liquor? Did she have above a 0.08? Guilty of a lesser included operating under the influence of liquor. This is just the DUI charge. And again, was she under the influence of liquor or was she above a 0.08? Absolutely clear to me. It would have been simpler if they had a A and a B, a not guilty and a guilty for each one of these. It's better. It's simpler. But I will say, this is not completely abnormal. This is not something that only happens in Massachusetts, set up like this. Okay? Additionally, do I think it will be an appellate issue? Yes. Do I think it'll be a winning issue? No. And I think we've already kind of seen this go through the appellate process. So why are we here? Judges usually don't like to upset the status quo. They don't like to be the first one to do something. They like the appellate court to tell them to do something if they are going to be the one to change their mind. They also don't want to be the one that they did it this way. Now every judge in Massachusetts has to do it this way if this is the way it's always been done. So while I agree, there's a better way. I have argued as a lawyer, why are we doing this like this, guys? There's a better way. Let's make the rules simpler. Let's do it the right way. Why are you doing it like this? But all the other lawyers in the room that have been doing it like this for 30 years are like, listen here, youngin', you're not going to come here and just change the way we do things. It does happen. It is frustrating. It is annoying. Ashley, so on the verdict form, can they not acquit on just second degree? Can they poll the jury on each count? If it's not guilty, they can poll the jury that it's not guilty. Polling the jury on each count, I guess they might be able to ask for that. But if it's the highest count, they're not going to poll on the lower lesser included. If it's a lesser included, will they poll on the higher counts? Maybe, I guess. I guess they could. Verdict form question, looking at the form as a juror, I think it could favor the defendant. If the jury thinks she's guilty on 2, there's no checkbox for not guilty on the other 5, so it could vote not guilty on all. If they vote not guilty on one, if they vote guilty on one and also check the not guilty box, they will send it back to the jury to correct the form and say it was not filled out correctly. Thanks for the great info. Happy Father's Day to you and your dad and all the great dads out there. Thank you, Kevin, so much. Why would the prosecutor say hard decision? I don't know. Maybe he meant like we're in a difficult spot. This isn't something easy to do. Not a buffalo on a prairie. What? I thought that was weird too. And probably not the best for a young jury. Mandy S. 5 a.m. video diffusers still lit up. Case closed. Okay, I am now going to jump back to the video so we can listen to this one jury instruction from Judge Cannoni on this verdict form to see if you guys think it's simple or what you think about it. All right. So here we go.
Do not make up your mind about what the verdict should be until after you've gone to the jurors. Please do not share them with the other jurors. Please consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Keep an open mind until then. For each indictment, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of that specific charge.
Each indictment beyond a reasonable doubt for that specific charge. Not all the charges, not wait till the end, nothing like that. Definitely better. I liked Yannetti's better. I liked the version that we read on the last or 2 videos ago on the charge conference. They made it as clear as possible, which I think, why not? It's like 10 seconds of extra words, Judge Cannoni, but it is what it is. I liked that better, but this is still better than last trial, I feel like. By the way, make sure you guys hit the like button if you haven't, and make sure you are subscribed to our channel so you can talk about the next case we talk about as well, because unfortunately, we live in a broken world and there's always going to be another case, and we want to talk about justice, talk about the system, see how the different lawyers and judges act around the country, learn about our justice system.
Your decision as to each charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive 1 verdict slip for each indictment. When all 12 jurors agree on the verdict for a particular indictment, the foreperson should check off that verdict and then sign and date the slip in ink.
I like that. I think that's good. So let's do it one more time. On each verdict.
Verdict slip, meaning that all 12 deliberating jurors must agree. You will receive 1 verdict slip for each indictment. When all 12 jurors agree on the verdict for a particular indictment, the foreperson should check off that verdict and then sign and date the slip in ink. For each charge, if you all agree that the Commonwealth has proved every element of the charge beyond a reasonable doubt, then you should find Ms. Reed guilty of that charge. On the other hand, if you all agree that the Commonwealth did not prove one or more elements of a particular charge beyond a reasonable doubt, then your verdict must be not guilty on that charge. You'll remember that we took a view in this case. It seems like a very long time ago, but we took a view in.
All right. So that was the instruction I wanted to get to. And I thought it was better than last trial, personally. Why do you think Cannoni let AJ and Hank Brennan go longer than 75 minutes, but cut Lally off at 60 minutes last trial? I think she knows it was too short, number one. Number two, I think these two lawyers would have fought with her for more time. Number three, I think she could tell they were getting close to the end. If it sounded like they were early on or in the middle, she may have done something, but that's why. And I think she did the right thing to let him go a little long. Peter, what are your possible winning appellate issues in this case? If she gets convicted, this is going to be a big part of a video we do. So I'm going to hold on that. Did Brennan listen to the trial we all watched? He was not hit by a car. Brennan is delusional. I heard she didn't hit him at least 5 times. Curious, as a civil lawyer, would you have prosecuted a criminal case? Peter, I would love to be a special prosecutor. I think that'd be fun depending on the case. Explain the temp slide from the prosecution, meaning missing 5 hours from 1:36 to 6:07. I think they're saying that's when it was under John O'Keefe, and that's why it didn't change. I mean, I don't know. Is the jury allowed to look up background information such as will a tail light up after a diffuser is broken? No, they are not allowed to do any outside research. Dumb questioners on, was it proven that the Lexus went in reverse at a high speed at exactly the time John O'Keefe hit John O'Keefe? Sub for more than 2 years now, and you give the best recaps. Started with Murdaugh. Was it proven? I mean, I think you got to ask the jury. Thank you for all your hard work, Peter. Very respectful as always. God bless you and Papa on this Father's Day. Thank you so much. Not having a better instruction on the sweatshirt killed me. I agree, but again, because good lawyers sometimes get punished for being good lawyers, because Jackson absolutely smashed that in closing, any appellate court is probably going to be like, the damage was done. Do you think this trial will be case law in the future? Maybe some aspects of it, but probably not as much as people think. All right. That's all we got. Love you guys. Hope you have a great weekend. Enjoy this weekend. Hug and kiss your fathers. Love them. Spoil them. They deserve it. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.